married. Sometimes the judge may award some damages to the affected party. You understand? Looking at the case. So that is how a caveat is removed. So you always do your homework before you move on to get married, so that you don't get any surprises from the caveat. So let's move on to ordinance marriage and marriage officer's license. Oh, is it? Okay. So this is the one that the ladies like. The veil, the gown, bridesmaids, all that. We like that. But let me say something little about the wearing of the veil and everything. So it's not really necessary, to be honest with you, because the wearing of even a white wedding gown started from Queen Victoria. She was getting married and she wore it with a veil, a long veil, and it was nice. And that is how, it started. So it doesn't matter if you don't have that white wedding gown. If you don't have that white veil, it doesn't mean you can't get married. You can still go ahead and get married. It is not a requirement anywhere that you have to wear white. Because sometimes people will wear champagne, because that is a color you identify with. Then people will be there gossiping at their wedding, all that. It doesn't matter. You can wear anything that you want to wear. We have given our own meanings to it, that it means purity and what not. But there is no legal backing to it. Okay. So with marriage, under the marriage officer's license, which is still the ordinance, this happens in church. And this is different from a blessing, and I will explain it shortly. So this type of marriage, unlike the first one, which is handled by the registrar of marriages or a judge, this is handled by church ministers and pastors who needed to act as marriage officers. So the church must be gazetted and the pastor must be gazetted. Luckily for us, our church is gazetted, and I think our pastors, as the new ones come, they are also gazetted. So you can get married here under the ordinance, and you see that it is the pastor that actually conducts the marriage, leads the parties to say their vows, ensure the certificate has been signed, and the pastor also signs and all that. So that is where the pastors get their power from to conduct marriages in church. It is through the power of the law for them to conduct it in church, because we know that some Ghanaians are Christians and they would want to get married in church. So most churches have peculiar processes, but this is the general requirement of the law, that you also apply. If you are in the same church, you can apply. If you are in different churches, you do, separate ones to your churches. And then you say that you are unmarried and request that banns of the marriage is published. So the banns is just a notice, okay, that is given to the church, informing them that you intend to marry. And you intend to marry this particular person on this particular date. And so if anybody has any just cause, I know when they say that sometimes some people just want to faint. If there is any just cause why you think the two should not be jointfully married or put together, you may now say so. So the banns has to be published on 3 consecutive Sabbaths or Sundays. So you say it this Sabbath, next Sabbath, you say it. And it has to be done during divine service, when, you have the full congregation seated, so that if there is anybody who has anything to say, you have the opportunity to raise that objection. It is the same as a caveat, okay? So you raise your caveat, and then it will be sorted out just as all caveats to marriages are sorted out. Then the bans must be published by the marriage officer. This thing, a lot of people or a lot of churches fault, and it's bad because it's not everybody who has the power to conduct marriages. So if the pastor is the gazetted pastor who is going to bless the marriage or conduct the marriage, that pastor must personally announce the bans. If for some reason the pastor is not there or can't do it, then the pastor has to appoint someone, maybe the secretary, the church clerk, the elder, somebody in that kind of capacity or authority to pronounce the bans. And that has to be, there has to be a written directive authorizing that person to pronounce the bans. If you don't do that, your marriage can be void just because bans were not published properly. So please, let's take note of that. So after the third publication, if no caveat is raised, or if there is a caveat but it has been resolved, then the parties can go ahead and then get married. After the ceremony, the certificate is usually in duplicates, in two. So you are given one, that's what they usually fold and give to the woman. Then the marriage officer has to return the other one to the registrar of marriages so that a copy will be there. I know that there are some churches that will give their own certificates. You know, there are some churches, they will give two certificates, the one from the government, then they will give a church one. That church one doesn't go beyond the door of the church. It has no legal effect. It has no legal power. You can't take it anywhere and claim you are married. I think they just give it as a recognition that the church recognizes that you are married. But the one that has the power that the women like to keep in their suitcases and then once in a while swing it and say that, you know what, I'm married, I'm Mrs. This or whatever, that is the one that is usually blue and white or green and white. You will see it. Yes, so the ones that they give to some people, it is of no effect. You can't take it anywhere. So then, is every church wedding marriage under the ordinance? Once I come to the church, I'm wearing my long veil and I marry. Is my wedding, is my marriage valid? Have I married under the ordinance? What if my husband and I have married under customary law on Thursday or on Friday, and on Sabbath we've come to church, we've stood here? You are doing that voluntarily. That is what counts, and having the certificate. So if you come to church and you ask pastor to bless your marriage, you wear the rings, but you haven't complied with the requirements for ordinance marriage, that is publication of the bans. And so you don't have a certificate issued to you with which you are getting married. My sister, it is just a blessing. It is just a blessing. There is nothing wrong with having your marriage blessed. But what I'm saying is that a blessing is not marriage under the ordinance. So if you marry under customary law, you are wearing the two rings, and pastor prays for you, you say your vows, you don't have the certificate, it is still customary law marriage. The value is the same. Whether you cut cake, your reception is nice, whether your veil was the longest, your dress is as white as snow, and you don't have the certificate. If your wedding is broadcast on TV, it is on Instagram, wedding of the century, and you don't have the certificates before getting married, it is just a blessing. It is just a blessing. And you are still married under customary law. So let's move on to the special license quickly. So this license, I know some people will like it, but I pray that the Holy Spirit speaks to you so that you are circumspect in how you want to use it. So with this license, look at the name, a special license. It means there are some circumstances that are preventing you from complying with the rigid formal requirements. And so we will still allow you to have a valid marriage without having your bonds being published. Amen. I know a lot of people would want that. No bonds, then you marry. You don't have to have a registered venue. I forgot to say that. If you have everything, but the venue that you marry at is not registered for marriage under the ordinance, that is the marriage officers. So if your church is not gazetted, the marriage is void. Don't even worry, it's void. But for the get married at Ebri, the place that you want to marry is not gazetted. There are family issues here and there. There are so many things. That is where you look at the special license. But you just don't go and pick it. You have to prove why you need to be given the special license. So you have to swear an affidavit to that effect. And an affidavit is evidence. It's like you are given evidence before a court. So if we find out that you lied, that is perjury. That is perjury, and that is a crime. So, you would have to really prove that you really deserve to be issued a special license. Once you are issued a special license, you don't have to pronounce bans. You don't have to paste anything anywhere. No caveat is expected. Nothing. The place must not even be registered. So the registrar will just write the place you're going to get married at and all that on it. That is also another form of mercy. It's like giving you something that you are not supposed to have. So you are not supposed to marry here. But because of A, B, C, and D, we will allow you to marry there. So that is the special license. So I think I've mentioned some of the situations. You can be issued a special license. Okay. So what happens if I don't comply? Or what are some of the things I can do to make my marriage void? I should go back. Okay. So if you don't comply with the provisions of Cap 127, so no bans, you don't marry at a registered place, or you are married and you still want to go on and marry, your marriage is void ab initio. It's void from the beginning. You are already married and you want to marry under the ordinance. That marriage is void. Nothing can do anything about it for you because we see it as the marriage never came into existence. You don't have the capacity. Let's say you are less than 21. You don't have parental consent. It is void. Because how do we know that your consent is not as a result of some fraud or influence? You understand? If the pastor blessing your marriage, especially for some of these small churches, if the pastor is not licensed, if the church is not licensed, forget about it. You do the ceremony, but because your wig is coming off, you want to go to the washroom and fix your wig, so you don't sign the certificate, there is no marriage. If you marry after that 3 months period, like the duration you've been given to marry, once they issue you the certificate, that marriage is void. If you marry at an unregistered place, no matter how beautiful it is, even if it's the Garden of Eden, once it's not a registered place, your marriage is also void. So how do we dissolve marriage under the ordinance? You can do that only at a court. You can do that at a court. You are not there yet. So you can only do that at a court of competent jurisdiction. Okay? You can do it as a district court, circuit court, high court. That's the only place. So as I said earlier, if you tear it, you are still married. If you burn it, you are still married. No matter what you do, you are still married. Okay? Then, once you are divorced, what the judges do is that they will cancel the certificate. So when they are reading the judgment of a divorce, which is usually a sad one, it's usually a sad one, they would say a whole lot of things, a whole lot of things. Then the final thing would be, and so this marriage celebrated between blah, 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 and the marriage certificate number so and so is hereby cancelled. And that will usually come in the form of a decree. So nobody can do anything about it. If you want your marriage back at this point, you would have to go through the whole process again and remarry. That is the only way you can come back from a divorce. So before you think of a divorce, you have to think twice. There is no coming back from it. It's final. There is no coming back from it. Then let's look at other matters concerning marriage. We have bigamy. Bigamy is becoming very common. Bigamy is becoming very common, and I'm sad to say that even in the house of God, we are doing it. We are doing it. You know, we marry, we come here, we marry, and then we marry again secretly. And unfortunately, some of our parents, Adventist parents, are supporting us. It's a shame. It's a shame. We are doing it. It's so sad. I never thought something like this, will be heard in the house of God. But we are doing it all over. And as I said, there are some Christian churches that they don't even say anything. They don't have anything to say about, being married twice as a Christian man. And they are doing it. But what we have to know is that bigamy is illegal. It is illegal. If you marry somebody and then you go and do it secretly somewhere, even if, I think some people believe that you can marry under the ordinance and then go and marry somebody else under customary law. You can't. That is bigamy. One, that marriage is void from the beginning because you are already married. Remember, ordinance is one man, one wife. So you can't marry again. You can't marry again. And then they marry and then they think it's okay. Oh, this one is customary. No, you can't. Either you are married under customary with both women, or you marry one under ordinance. You can't mix and match the two. And it is a crime. Okay? You can go to prison for at least 3 years, for at most 3 years. And you can also be fined. It is a crime. So please take note when you are doing it. And usually, it's not just the person who gets married, but maybe the parents, the pastor, abetment of crime. So all the people that help the person to actually get married twice are also liable. So please, let's be careful. If you want this lady, marry her. If you don't want her by whatever reason, of course, we are Christians and we don't preach divorce. But it is better for you to dissolve that marriage than to marry another woman and come for communion. May God forgive us. Amen. So another issue too is same-sex marriage. Still. Okay. So this one, I won't even talk for too long. Same-sex marriage is not recognized in Ghana. That has a stance of, it's God that hates it. Even if you are not a Christian, you can't marry the same sex. It is illegal in Ghana. It can't be done. Marriage is between a natural man and a natural woman. What you should know is that most of the law is derived from the 10 Commandments. God in his own wisdom, has made it so. So same-sex marriage is not recognized in Ghana. So we will not even sweat about it. Amen. Amen. So we've come to the end of the first presentation. We've spoken about the marriages that we have. We know there are 3 types: the customary, marriage under the ordinance, and then the Mohammedan, which is the Muslim one. We've looked at customary law marriage, where it's potentially polygamous. We've looked at ordinance marriage, where you can marry in 3 ways. So, yes, and we've also looked at what to make your marriage void under ordinance marriage, and we've also looked at some of the other issues pertaining to marriage. Thank you so much for your attention. I know you have questions, but please let's finish with the spousal property, and then we will take all your questions. So please, if you have a question, just note it. Once she's done, it will take a few minutes, then we can take all the questions for you. Amen.
It's been an interesting presentation. Happy Sabbath to you all. So, as you know, I also can't see the screen from my end. So Angela, please prompt me as we move. Okay. As Jackie started, my colleague started, she has taken us through marriages. So as we get married, you could see my first slide. I quoted Psalm 127, verse 1. Unless the Lord builds the house, the builder labor in vain. So as we get married and we go through the marital journey, one of our prayers, as we are cleaving, we are asking God for children. And also we are asking God for his blessings. So we acquire properties during the subsistence of the marriage. So we work hard and we acquire properties jointly or individually during the marriage. But one thing that I want us to note is that when we do the church wedding and we come to church, we take our vows, as she rightly said. And in the vows, we say that we will love each other until death do us part. So as Christians, the only reason that you can come out of a marriage is death. But as we are saying this vow, we are not ensuring each other that we will have the strength to embrace death. But what we are praying is that death never visits us, so that my partner would leave me. But one thing that we should also note, which is so silent in our Christian setting, is divorce. Angela. It's divorce. And when divorce or death happens, backwards. So when divorce, any which way that we find ourselves that we are parting, either divorce or either death, there is one thing that drags the couples through tongues and sometimes nails. It becomes difficult. And that essential part is spousal properties. So one will ask, what is spousal property? Spousal property is properties acquired during the subsistence of the marriage, being it jointly or individually. So we are married. We put our resources together. We try to put something up. So that is spousal property. Or the man puts up something whilst we get married. That's a spousal property. But it's so interesting. When it comes to death, or when it comes to divorce, that is when this matters. Spousal property comes up. But when the love is lovey-dovey, oh, after a honeymoon, we are happy, we don't think about such things. But we only think about spousal property. But as Christians, we can have an arrangement between us as couples that we are doing it, we are building it for our children. Because a good father leaves a legacy for his children. So if you have that mentality from the onset, it helps you. So the law in Ghana regarding spousal rights has evolved over the years. But before we talk about the current position of the law, which is the principle of equality, we would go through the stages that the law has gone through for you to appreciate it. So before the coming in force of the Matrimonial Causes Act that governs anything pertaining marriages, and also the 1992 Constitution, the only law that was present was the customary law. So we will look through it, and also we'll talk about what we are supposed to expect in future. So we'll go through all these things. So before the enactment of the Matrimonial Causes Act, I'll take that one first, and the 1992 Constitution, the customary law position on spousal property. So this position is that when a man and a woman gets married, they acquire property. The notion is that the wife is just a helpmate. So you help your husband to acquire wealth. Then when your husband dies and doesn't leave you with, states that when I die, this property should go to you in a will, you get nothing. So you just work, help the man to acquire. Because the main premise is that the man is the head of the family and the primary provider. So you as the wife, what you can only get from the marriage is maintenance, housekeeping money, chop money. That is all that you are entitled to. And also support from your husband. Isn't this discriminatory? So you don't get anything. And when the man dies, so for instance, a proper Akan cocoa farmer, a woman will help, go to the farm, weed, cook for the laborers, live in a desert, like a forest. And, okay, please let me finish the slides, I'll come back to you. and help the man. And help the man to acquire properties. And when the man acquires properties, and the man dies, it goes to the man's nieces and nephews. Then the woman is sacked from the matrimonial home. This is what I'm talking about. That was the position of the law, and you can't do anything about it. So in the Ghana setting, it goes to the man's paternal family. The woman is sacked out from the matrimonial home. So that is what I'm talking about. So the court saw that it is discriminatory. So they brought about the principle of substantial contribution. Substantial contribution. I should go back. Go back. The principle of substantial contribution. Okay. So the principles of substantial contribution. So the principle of substantial contribution, that was the only law. And when the court says substantial contribution, the court means that you have to show that, you have to prove that you've contributed. So if you are living together and you're a wife, you have to show that you've done something to acquire that property, so the court should allow you to benefit. So that is the principle. So after the customary law position, then the court saw that it's bringing a lot of injustice. So they want to resolve that problem. So they brought about the principle of substantial contribution. But how does the court determine whether or not a spouse has made a substantial contribution? So the courts decided on case-by-case basis. So it's not automatic. It's not certain. You have to prove that I contributed A, B, C, D. And this substantial contribution principle applied in ordinance marriage, as Jackie explained, and customary marriage. So it applies in both scenarios. So I'm going to give a scenario. A, case A. The parties got married under customary law. The wife contributed to the plot that was purchased for the matrimonial home. The wife bought building materials. The wife was supervising the workers. The wife was cooking for the workers. The husband died. The customary successor secretly went to sell the matrimonial property. The wife went to court. The wife said, no, I have contributed, so I have to benefit from the matrimonial property. The court said, yes, she has suffered. She has contributed. So the court declared the wife as a joint owner, so she has to benefit from the matrimonial property. Case B. Case B. Case B. Case B is when the parties were married under the ordinance. The wife was a housewife. The wife wasn't working. The wife stayed at home. Then there was divorce. There was divorce. Then the wife goes to court saying that I've given my husband peace and tranquility to acquire all these properties, so I'm entitled to a share. The court said, no, you are not entitled to any share because, one, you were not working. Two, if you were working and the husband told you that quit your work and come and stay home, take care of the kids, for that one, we would consider. But for this one, you are not entitled to anything. So it's determined on case-by-case basis. One thing that you can also prove substantial contribution is that, next slide, is that continuation. We are on continuation. So one thing that you can also prove substantial contribution is that, one, where there is an arrangement between the parties, that the wife, use your money as housekeeping money. I would also acquire properties for our benefits. Please, do you get it? We are living together. You use your money for housekeeping money. I would use my money to acquire properties for the benefit of us. And most ladies suffer. They can use this thing. Some men use this thing a lot. Oh, I'm acquiring properties for us. The wife would use her money, her resources for everything. And the man will put his name on the title document, leaving the wife, and the wife does not get anything. The court will say that since there was an arrangement between you people, because one thing that we should note is that in marriages, normal commerce does not apply. That there is an agreement, so your name has to be on it. It doesn't apply. So far as you people have agreed that use your money for this, and I will acquire property for our benefits, you have given her assurance. She could have used her money to acquire properties for herself and probably her children. But you decided that use it so that you benefit. So in events that it goes to court, the court will say that she's entitled to benefit. So we should also look at that. So substantial contribution appears to impose some degree of unfairness on some spouse too. So even though the customary law is unfair, substantial contribution is also unfair. So it's not a blank check that when you go, you can benefit. So it's case by case. So there was no certainty in the law. So you go to court and you don't know whether you are going to, the court will say you will benefit or you will not benefit. So especially for housewives, some housewives also gives their husband peace, tranquility, as case B was saying, to acquire those wealth. Because if a man is suffering from home, not having peace of mind, the man can't acquire those wealth. So I think at least I've given you something, so the court should consider. But the court said no. So as the law develops, now there was the enactment of the Matrimonial Causes Act, because there was apparent injustice and uncertainty in the position of the law. So, in respect of the customary law position of the law, spousal property, in respect of substantial contribution principle. So, the Matrimonial Causes Act, the whole act, the only portion that talked about spousal property was section 20. And in section 20, it says that in event of divorce, so it doesn't talk about spousal property anywhere. Section 20 says that in event of divorce, as part of financial provision, you can convey a property that you acquired during the subsistence of the marriage to the wife. So even with that, it's also not certain. So if we acquire property together, I live with you, acquire property together. And unless we are dissolving our marriage, that is when you can decide, or the parties can say that, okay, instead of giving you an alimony of 50,000, I would give you a house and 20,000. So then the court, since laws are developed and laws come up by case law and legislature, then the 1992 Constitution comes up. The 1992 Constitution comes up. And the first time the court applied the 1992 Constitution in deciding the case was in the case of, the principle that they proposed was equality. So, still, no, let's go back, let's go. So, since with even the Matrimonial Causes Act, it didn't give a clear and certain outcome of cases that goes to court. Now, the court decided that, okay, since still we are not having a clear disposition about what to benefit, how to benefit, now the court tried to apply the principle of equality when it comes to distribution of property. So the court said that regardless of whether you've benefited, whether you've contributed, whether you've done this, so far as you are a spouse, you are entitled to 50% share. Whether you've contributed, whether you've not contributed, if the property was acquired during the subsistence of the marriage, you're entitled to 50%. And most wives now are happy that, oh, even if I sit at home and I don't work, and probably I go to courts, and there is divorce, I'll be entitled to 50% share. But one thing that I'm telling you is that the court will look at the facts of the case and decide So every case is peculiar. So it's not a blank check that 50%. So when you go, the judges will sign and give it to you. No. So we should also note that. One thing that we should also note is that even though the courts try to apply equality or equitable distribution of properties, the court will look at the facts of the case. Because there are some women who are career women, they are working. Your husband will tell you, I've acquired a land at this place. You say, okay. You use your money for Brazilian hair. You use your money for makeup. You don't contribute. You don't do anything. You are also working. Probably your husband has taken a bank loan to just build the house. The court will say that you are not entitled to anything because you are also a career woman. You are a woman of means. You should have helped your husband. So the 50-50 is not a blank check. So we should note it as wives that we are helpmates. So we should help our husbands and not to just sit at home and just watch the men suffering. And in the end, you come and say that I have a share in the property. That is what most women are interested in. But we should note it. And some men too likewise. Some men too likewise. So I would say that. Okay. One thing that would also have to discuss is that when the Supreme Court decided some cases, there were certain implications that we have to note. And one of the implications is that if the properties were purchased by even one of us, our funds, instantly you become a joint owner in law. Then also, another implication is that your husband, if you are living in that house that was acquired, even if the money came from your husband cannot go and use that house as a mortgage without your consent. Do you get it? Or enter into a long lease without your consent. And even now with the current Land Act, it states it again, that you can't do that without not involving your partner. So even if the land is in your name, you've registered in your name, you think you are the only person who used your resources to build it, you can't enter into a long lease without involving your partner. So you should note it, please. Also, with the suggestion of the Supreme Court, they thought that some men, as Jackie said, will secretly marry, try and take a loan, use that matrimonial property as collateral, then go into hiding, then default. He would intentionally default. Then the banks will come and sell the property, the matrimonial property. Now, as a wife, you can go to court and interplead with the court and say that I also have a share in the property, so the court can look into it. So you can't mortgage the whole, you can't sell the whole property. So you can sell his share and use it to set off the debt. But my share, I'm not selling it. Please, do you get it? Yes. So some men can be very crafty. So he thinks that I'm not interested in the marriage. He won't go and divorce so that you take the 50% share. He knows very well that you've contributed. So he will secretly do certain things and they will come back and sell the property. But the court won't take it lightly. So we should note that. One will say that after the Supreme Court decision, so can I, a spouse in a marriage, acquire a property individually? Yes, you can. Yes, you can. Example is what I said. There are instances where you acquire properties alone. Because right from the beginning, probably you don't have a joint account that you can say that you use those monies to build the house. 1, 2, the wife is working, but he's not supporting. So in that instance, the court will say that you are also working, you should have helped, you didn't help, I've used my money. There was an instance. that the man sets the wife up to open a shop. The man took a loan from HFC to buy a house. Now there is a divorce. The wife says she is entitled to a 50% share of the house. And I asked the woman during course examination that, does your husband have a share in your business? She said no. So you see, in her business, she see it as it's for her. So if the man is also working in his money, it's for him. So right from the beginning, there is no intention that both parties will benefit from each other. So the woman is not entitled to it. And the court said, yes, you are not entitled to it. Had she said that, yes, the man is entitled to the proceeds of my business, but he's not asking, then the court would even infer that then there is an intention that both parties will benefit. So if there is not that intention, then you can't benefit. So we should be careful. It's not blank check that when you go, the court will say 50-50, and we should be very careful. Okay, one thing that I would also like us to discuss is the future. Now there is a bill in Parliament. So I pray, it has been in Parliament for long. The Spousal Property Act. That I think when it comes out, it will help a lot of women. Especially, you see, as we were discussing, Jackie was discussing customary law marriages. It's potentially polygamous. So when the man dies, probably the first wife helped the man to acquire those properties. But under PNDC law 111, it says that order of priority wives. So even if the second wife, when he came, all the properties were acquired, the second wife will benefit. Do you get it? So if this Spousal Property Rights Act is passed, now it is clear that in the bill that if the man dies and the man was able to acquire one property with the first wife takes it. So if the second wife comes and the second wife also acquire property with the man, it's for the second wife till the fourth wife. So that people won't take advantage of where they've not benefited, where they've not sweat. You can't benefit from where you've not sweat. So one thing that I would say is that we should try and get a lot of female parliamentarians so that this bill comes out, because it's really going to help women, especially when you are, because probably your husband says, I won't marry you under the ordinance. I will marry you under customary marriage. It's potentially polygamous. You help, and other person will come and benefit. So the law says we should, the first wife benefits, you don't benefit when you come and work and it yield fruit, you eat from that fruit. So now the monkey they work, babu they chop principle is out. So I think it's a good bill, and I think we should pass it, because a lot of men don't want it to come. So please, I'm praying that a lot of women should go to Parliament so that we pass this bill, because it's really good, and I believe that. Also, let me see, slide 19. Okay. Also, in conclusion, I would say that it is good to marry, and it's equally good to build properties together as husband and wife. But looking at all these things, I believe that when it comes to divorce or when it comes to any issue, try and settle your matter yourselves. Because, especially with properties, and if God has blessed you, you have 2 properties, and in event of divorce, you can say that take one, I take one, we go our separate ways. But a lot of people don't understand, so it becomes and it's not good. But if you are able to settle your matter, you go to court. It's only in respect of the dissolution, as Jackie said, of the marriage. So the properties, you parties have decided. Other than that, The court will decide on the merits of the case. And you see that you are not benefiting. You say that, oh, the courts didn't do their case, their work well, but it's the law. They will apply the law strictly, and it won't favor you. So that is what I would say. As Christians, anytime that there is an issue, and if there is a problem and we have to resolve it, we should resolve it, especially in respect of spousal properties. We should try and resolve it. So please, also one thing that I would say is that as young as dating, when we are courting, and you see that the man has acquired his property, then you go and invest in that property. At that time, that land was not acquired during the subsistence of the marriage. So it will not be termed as spousal property. So when you come and he's building, just look at it until he marries you. Even if he marries you and he has not completed the house, if you like, you can invest. But if not, you can decide not to invest because you won't benefit. And in Ghana, we don't look at the property, we look at the land. Now, the lawyer of the man will say that the land was purchased whilst you were not married, so you can't benefit. So please, don't go and invest in certain things. Some people will go, the man is building a house in his father's land, on his father's land. You go and invest. Me, when I see that, I won't put my money in it. No, don't do it, ladies. You see that the man will die and they'll come and drive you out of the house because it's a family land. It doesn't belong to the man. So if he's bold, he should go and get his land. Both of us will build. So please, ladies, let's be careful. And we shouldn't invest in ventures that won't profit us. So please, as Christians, the Bible says we should be as wise as a serpent. So please, we should be careful. So during dating too, we should be careful. Some men will come, oh, I'm going to sites. Oh, let's go. Oh. So you help me, don't help him. Until you see that you are married. And please, the land that he purchased is during the subsistence of the marriage, you benefit. Thank you.
Question. Okay, please, who is going to coordinate the questions? Let's start. Yes, Angela, can you?
So if you are ready to ask questions, you can move to the mic over there. Thank you.
Yes, boss, please go ahead.
Hello. Okay. Short, yes. Number one, can you convert an ordinance to customary marriage if you can do otherwise?
You can divorce. As for ordinance marriage, I said the only way to come out of an ordinance marriage is divorce. So you can divorce and then you go and marry under customary. You can't convert it the other way around.
Okay.
It's only customary that can.
It's okay. Number two, marriages that are held on public holidays, are they valid?
If you have, if the certificate allows you to, then it is.
How would that happen? If I marry, for instance, on like a 1st July, no, July is no, but that's the date I remember very well. If I marry, yes.
But you use the marriage officer's certificate, isn't it?
Okay, yes.
You married in church.
Yes, I did in church.
Yes, so it is valid.
Valid, okay. The last one.
Because you know the courts won't open on weekdays, so for the registrars you can't do it.
Okay. Okay, so is it a crime if as a man, I'm living with my wife and we do not marry, we want to live, we don't want to marry because we don't want any problems. Is it a crime to do that?
No, it's not a crime. I think I touched on that. That is the common law marriage or cohabitation. But as Christians, we are not advised to do that because you are not a wife. If he should die, the courts may have mercy on you and give you some of the benefits that a wife is supposed to have, especially if you have children, but you are not a wife, so you won't have full benefits. And as Christians, we shouldn't go into that, but it is not a crime.
You made us to understand that under customary law, the ring is under customary law. So you marry under customary law, the ring is optional. It's not a requirement. Oh, sorry. But what about traditionally? Some families demands, like among the guns, it's a demand. It's required. The Bible and then the ring. You go to the family and they'll give you requirements for what is that? The list. And on the list it is there. And then the engagement itself, what you call them, the marriage itself, they call it gawo, which means ring, presentation of ring. That is the name they give to the marriage. So the man, what do you do? Then, okay, maybe you answer that.
So in that case, generally, initially, the ring wasn't a part of it.
Yes.
But because we've now become, I think Ghana is a Christian country, so we have inculcated some of those things into our traditions. And I said that for customary law marriage, it is between the two families. You need the consent of both families. So when you go and the family says that this is what I am requesting, then you have to comply if you want to marry their daughter. So in that case, you don't have a choice. But where it is not demanded from you, then the two of you can decide, to forgo it.
Now, the second one is this. The ordinance marriage, the place, the venue must be gazetted. Then the minister himself must also be gazetted.
Yes.
Otherwise, it becomes null and void. Yes. Okay. Now, in such a case, if the minister is not gazetted and he goes ahead to conduct the marriage is null and void. What is done to that minister? He is not supposed to have done something, and he has done it. What is the implication?
Yes, I think maybe maybe the married couple can take him to court for damages or something, because maybe the person misrepresented, gave you the impression that he is licensed, especially if you attend the church. People think that I can get married in church. The church is gazetted. The pastor is gazetted. So you also have to do your homework, especially if you don't belong to an Orthodox church or something. But some of these little mushroom churches, you have to do your research and make sure that the pastor is, a licensed marriage officer. Other than that, the only remedy you may have is that you go to court, maybe take the pastor to court, and say that you spend so and so amount of money conducting the ceremony, so the pastor should pay you. That is all you can do. The marriage is still void.
Yeah. So on this, I would like to educate our members. We have three categories of ministers. We have licensed ministers, then we have ordained ministers, and we have ordained gazetted ministers. You see, the first two, the licensed ministers, pastors who are not ordained, they are not entitled to conduct marriages. Ordained ministers are also not entitled to conduct marriages. This only the ordained ministers who are gazetted. So before you choose somebody for your wedding, your counselor, make sure you make your investigations, your research well. So thank you very much.
Thank you very much, Pastor.
It applies to counseling as well.
The family life, when you want to marry, then they will direct you.
Yes, when you can go direct. Normally, the one who will do the counseling is supposed to be the one who will bless the marriage, that is, they conduct the wedding. And he has done the counseling, and he's not entitled to do it. So, before you do the counseling, you should be ordained and you should be gazetted before you do it. Thank you.
Thank you, Pastor.
Hello, happy Sabbath. Please, can you kindly explain what a prenup is to me and what it can be used for?
Okay, so a prenuptial agreement is not valid in Ghana yet. Because, yes, you can't go into marriage. You know, Bridget has spoken a lot about the pasiebo, the cheating thing. We are now going to enter the venture. Then we enter into a binding contract that if this should happen, you take this, I take this. Elsewhere, it's legal. But here, it is illegal. You cannot do it. But maybe amongst yourselves, you can have some sort of understanding. And then maybe by your conduct and your actions, as she said, when you get to court, and there was the understanding that this is how you will deal with your property, then the court will look at that. But you can't take a prenup and tender it as evidence in court. US, maybe you can, but Ghana.
I would also add that in Ghana, our laws are clear. Properties acquired before the marriage, you don't benefit. Properties acquired during the subsistence of the marriage, you benefit. So there is no need for even doing a prenup, because those properties are clearly demarcated. You don't benefit. So in Ghana, we don't accept it.
So if there's a contract and the lawyers of both parties are present and they clearly state what they intend to do with their properties in case of anything, and they just have that contract, they don't call it a prenup, they just have a contract. Does that apply here in Ghana?
And it's still a prenup, and in Ghana, there are no laws governing it, so it doesn't exist in Ghana.
And there's no bill, they're not trying to pass a prenup?
It's not in the spousal bill.
You see, so let me say something. You know, in law, sometimes something can have a name, but the form or the substance will be different. You can say that this is a church, but when you enter, it looks like a dwelling house. So the court will look at what is inside and decide whether it is a church or a dwelling house. So if we enter and there is church there, but there is a sofa, bed, kitchen, the court will say it is a dwelling house. So if you do any form of agreement and the court sees it as a prenuptial agreement, it is still null and void. It doesn't matter what you call it. Once it pertains to the marriage you intend to enter into and the properties, you know, how you are going to deal with it, then it is still illegal. So you can't do that.
Okay. My question is, like you said, before you got married or after you married, everything was rosy, everything was sweeter than honey. So let's say the man and the woman are together, right? But the woman is the one who is making the properties. And because everything is rosy, you decide to put both names on the properties. And then maybe after some years, it becomes bitter, as bitter leaf. And you decide to go your separate ways. In this essence, can the woman prove that I used my resources to build or make these properties, but then we had to put our names on it because we were married? Thank you.
Thank you. Thank you. In that instance, since you place your husband's name, the man's name on the title document, then there is an intention that you want him to benefit 50% of the property. So even, you see, in marriage, normal commerce does not apply. So even if you are acquiring the property, it's better for you to put it in your name, so that the court will say that you worked. So probably it's mine. It's mine. He can't do anything about it. But so far as it's in your name, you have evidence, you have everything. But on the title document, his name is on it. So then there is an intention that he should take benefits. So he's a joint owner, so he should benefit 50% from that property.
Okay, so what if, you know, you said it's always not like a cast in stone decision.
Yes.
So you have all your payments, your bank transactions showing that everything came from the source was you. And even if there's an intention, would there still be that 50%, or the court can consider that there is due evidence that you maybe wholly or 95% faulted that property? Will you still have the 50%?
So,
because sometimes it's difficult when you are married and you're making properties and you want to put it in your name alone. Then it's like you have an intention, you want to be alone, because when you marry, you become one, right?
That is
but
what
things don't go as we expect for it to go. In that instance, what do you do?
So in Ghana, that is what I said. In Ghana, we look at the land. We don't look at the building on it. Do you get it? So at the time that you are purchasing the land can be in your name. I've purchased it. It's in my name. But the moment that you say that it's Mr. and Mrs., especially people do it without even not gazetting their name, they put it on it, Mr. and Mrs. so and so.
I think I forgot to say that as an implication of marriage. So once you marry, under the ordinance, you are not an automatic Mrs. A unless you go through the right processes and change your name. You are still to be referred to as Miss A. So let's say I am married to a Mr. Boache. I don't automatically become Mrs. Jacqueline Boache. I will still be referred to as Miss Jacqueline Asante Mensah until I swear an affidavit and gazette that I now want to change my name to Mrs. Jacqueline Boache. Then I cannot be called Jacqueline Boache. But what we see is that we get married on Sabbath. Then the following Sabbath, when we come,
They are calling you
Mrs. Boache. Please, you don't exist though. You don't exist.
So the court will look at that your intention. That is what, you see, the court is just there to help you. So if you have all your receipt that you built, then the court perhaps will say that, have a little mercy on you and say that, okay, probably the man will have 20%, you have 80%. It's case by case, as I said. Even under the 1992 Constitution, the equality, the court looks at what is fairness, what is just, and what is equitable. That is what they will use to decide. Yeah.
Okay, so mine is a follow-up question to what she just, and an example. Okay, so in my case, we built the house after we got married, but it was on a family land. The father gave the land, but we didn't register it in our name, and we built on it. Then when we got divorced, he presented a petition that the house belongs to the family. I was at a loss. The court asked me to produce receipts of expenditure I made on the house, because we built it together from scratch. Or a witness from his family to say, yes, she contributed to that house. But here's the case, he's rallying his people against me. When I was moving out of the house, I didn't pick a receipt of any of the expenditures. Even though he himself said he remembers I bought a roofing sheet. I spent so much, but not to go into details of, but the court wanted evidence. And he had the evidence with him. I couldn't have it to prove it. So like you said, they were using the land. The land is still in his family name. I lost in that instance. Then the second one, a property we acquired together on mortgage. It wasn't finished in the course of the court proceedings whilst we were going through our divorce, but along the line, we had a call from the mortgage house. The house was ready, so we should come and pay the insurance and take it. Because it was joint, my name was on the document, so they called me, because my number was there. Then I asked my lawyer, what do I do? He said, tell him, when he goes to pay the insurance, we'll file an appeal to that effect, because in this case, you have two properties. Quickly, when I told him, he went to change the documentation and took my name off.
You shouldn't. That's right. No.
So here's the case. I needed the court to do something. And my appeal was overruled. So these are some of the things. As she's saying it, they are not stories. These things are real. When you're in marriage and you're doing this joint, they keep evidence. Yes, you are in love, you are in marriage, you want to do things together. You can't do it on your own for the person to think you have ulterior. Nobody enters into marriage with a motive of getting divorced. But when these things happen, the other party becomes like, I don't know, as if he doesn't know you. They will treat you like you are nobody, irrespective of the children and everything. And it's so bitter. I got tired. I boycotted the whole case. I didn't pursue anymore because I was tired for 3 good years. The divorce was granted all right, but I boycotted it. But these are some of the realities. So just to share with you, these things, as she's saying, they use evidences. The court will ask for documents. They will ask for so many things. If you don't have it, it will take God's intervention. Thank you.
Thank you to Madam. One thing that I will say is that it's sad it turns out that way, but for the joint property, for the family land, right from the beginning, I told you that you won't benefit. Even as people, sometimes as even not married couples, our families, your father can say, I have given this land to you. Let your father do a deed of gifts in your name so that it becomes your property. But if your father does not change the title, it's still your father's land. So if your father is not there, your siblings can also come and claim. So for the family land, it's a non-starter, she won't benefit. But for the joint property, she shouldn't have called him. He should have gone to the bank because she is also a joint owner. So if there is anything that went behind there, then probably fraud might come in. So she can institute a criminal action against the husband because at that time the case was in court. So you can't change any document at that stage. So I think that is what I was saying. You see, she said she got tired.
Please, is there a case that can be pursued or disclosed? Is there a case that can be pursued?
After we'll talk to her.
Okay, so mine is a concern. During your presentation, I noticed that you were saying if the man dies, if the husband dies, and I was like, is marriage all about the woman waiting for the man to die so that they inherit?
Oh, it's spousal, so it can be either way round. So it's a man or a woman. So please take heart. But you know, in our setting, usually we think the man will die and leave the wife. It's a presumption. That is
and then for the second question, I think when Mansa was here, she was like, if the woman did the property in her name and then goes to court and all that, I'm also like, the man gave you peace to do your property.
Now the court has moved. If you realize, I told you that the substantial contribution, where the woman said, I've given you peace to get this, I've given you peace to get that. The court said no. Probably you were working. So if, for instance, you are working, your wife has gotten a scholarship to study outside. So there is nobody to take care of the kids. So you have decided to quit job, take care of the kids. Your wife goes to school, work, gets money, acquire properties. Then now your wife says, hey, me, I will leave you because now you are nobody. So the property, I will take it. You can go to court and say that me, I was a civil engineer. I was working. This was my earnings. Now, you said you are going to school. I should sit at home, look after the kids. A man, 5-year-old child, 6-year-old child, now the children are grown. You are saying that I won't benefit from the property that you have acquired. The court will say that you were working. In that instance, unless you're a housewife, you are not working, or you are just at home, you are not working, and you look after the child, fine. It's just a prudent husband, what you do to support your wife. But if you are working and your wife says, quit and stay at home, look after the children, do this, you are entitled to it. That is when you've given her peace to acquire those properties. But not when you are lazing about at home, you want to benefit. No, no, no.
Okay, so in an event where both are working, and then one deliberately decides not to contribute meaningfully to the project or whatever property you are acquiring, what happens?
You don't benefit. Because you should show interest, you should contribute. You should contribute.
Okay, thank you.
Thank you.
Okay, please, my question is on alimonies. In the issue of alimonies, is it given for once? Do the both of the parties, do they sit to decide on how to go about it? My second question is about the 21 days notice before you get married. Like you gave the example that maybe when he was doing his national service, he gave birth with a certain lady in the village. What if the lady in the village did not see the 21 days notice and they go ahead and get married? What happens to the lady who has just found out that they are married?
Okay, so the first one with the alimony is usually a lump sum. A lump sum meaning a one-time payment that is awarded to the woman in a divorce as compensation. So it is a lump sum. You may not have the money to pay it at once. So you can pay it in installments depending on the judgments of the court, or in case you settle the agreements you have between the parties. But when it comes to maintenance for children, that is a monthly thing. So maybe you may request that the man, or if it is the woman who is gainfully employed, and maybe you have custody, the person pays a certain amount every month for maintenance of the children. That is different from alimony. The alimony goes to the woman, is a compensation package, usually a lump sum, but it can be paid in installments if you don't have the money. Because sometimes it is huge, depending on the wealth of the man.
Okay, so what if it's given and the woman in question is not satisfied with the amount given? What happens?
That is so during divorce proceedings, it's two things, it's two ways. Either you settle, so the settlement is you and your lawyer, he and his lawyer, you meet and you try and agree. A settlement is usually a compromise. You may not get everything that you initially asked for, but since it's a compromise, you take what you can get. You may ask for something and then it is not within the strength of the man. There is no way a court will order your husband to pay you alimony of 1 million when your husband is a watchman and his salary is 600 cedis a month. You understand? The court will look at what he can afford. So if it is in the matter of a settlement, then that is the place where you can let the man know, I'm not satisfied. It's negotiation. So you go back and forth until you agree, but you also have to compromise, looking at what the man can afford. And then you reach an agreement. Otherwise, if it is a judgment of the court, once the court gives the judgment, based on all the evidence that has been submitted, you don't have a choice. If you are not happy with it, the only thing you can do is to appeal that amount that was awarded you is small. So it should be increased. Okay. Yes, you can do that. And then
the 21 days.
Yes, so if once you are married, you cannot marry. So it's void. Maybe in the beginning, nobody may know. Okay? But it is still void. Once somebody gets to know, that is it. Even for void marriages, you don't even need to go to court and worry yourself for any declaration. Because it is void. Okay. You understand? But you can still go to court because you want the declaration to prove that so and so's marriage is void because I am married to him. Right. So it doesn't matter. So every day for the thief, one day
for the master. Thank you.
I want a clarification. Can a woman also give alimony if it is the woman who is divorcing the man?
Yes. You know, even if you are the respondent, even if you the woman, you are the respondent, so it's the man that has initiated the process. But the woman is rich, and you the man, as she said, you lived with her, maybe you've endured certain things, you sacrificed certain things, you can also ask for a lump sum. They usually ask. Some very wicked men will ask. Will ask for it, but as to whether it will be awarded, that is at the discretion of the judge based on the evidence that you would file.
Okay.
Please, my question is, you married in a case where you marry under ordinance, but you married with children, like the paternity of the children are not your husband's children. Like the paternity is not related to the man you married under ordinance. And in case the man passes away, please, I'm not, so in case the man passes away and there is issuing of property, are the children banned to, enjoy the properties?
The man adopted the children formally.
In two cases, let's say if there wasn't any adoption, but you married the man under ordinance, are the children entitled to?
The children are not his children. And even if the man died, unless the man in his will states that this property, this thing should go to these children because it's a gift in the will. But if the man does not expressly state it in a will, and the man dies interstate, the children will not benefit because they are not the children of the man.
So if he doesn't adopt them,
if he doesn't adopt them, but if he adopts them in Ghana, any child, even born out of wedlock, is a child. So then they can benefit.
Well, I'm asking this out of curiosity. You did say that for the marriage to be legal, the minister has to be gazetted as well as the
venue.
Okay. Well, as well as the venue. Now, I have read in magazines, there are people who chose their